my name is Marina. I'm a third-year law student at the University of Pennsylvania in Philadelphia, and today we're going to talk about the famous Supreme Court case, Burwell versus Hobby Lobby stores. This case is from 2014, and it is one of the most famous, well-known, and highly debated cases in modern history. On the day the Supreme Court heard arguments in the Hobby Lobby case, huge crowds gathered in Washington, D.C. outside of the Supreme Court building, holding posters and chanting on both sides of this case. People found it extremely polarizing. Even the Supreme Court justices found it polarizing. This is what we call a 5-4 decision. So as you know, there are 9 Supreme Court justices. 5 of them thought they got this case right, but 4 of them thought the other side should have won. So this was a really close case. And you'll see why it was so divisive. It affects women's health, religious freedom, employment law, and corporate law. So it was highly impactful on society, and people had strong views on both sides. So I think this is a good time to note that sometimes as lawyers, you have to represent clients that you might not personally agree with. And in this class, if you end up debating this case, you might be assigned to the side that you think is wrong, that you disagree with strongly. But there's still a lot of value in that exercise. You know, if you are representing someone you don't agree with, you get to think about the issue from all sides and try to understand what is motivating both sides and understand the people who might disagree with you. So this is a fantastic activity no matter what side you're assigned to. And with that, let's get started. So to understand the Hobby Lobby case, we first need to learn 2 of the relevant statutes. The first is the Affordable Care Act, what's commonly known as Obamacare. It has something called the contraceptive mandate. So the Affordable Care Act requires employers to provide health care plans to their employees, including covering the cost of contraceptives for women employees. Contraceptives is basically the same as birth control. So under the Affordable Care Act, employers have to cover the cost of birth control for their employees. The second important statute here is the Religious Freedom Restoration Act. I'm going to call this RFRA. That's how people usually call it. I know it sounds a little goofy, but if you hear me say RFRA, I'm talking about the Religious Freedom Act. RFRA says that any law that substantially burdens a person's exercise of religion is invalid. For example, if Congress passed a law that said no one can leave their house on Sundays, RFRA would probably invalidate this law because people who are Catholic need to go to church on Sunday. So by saying you cannot leave your house on Sundays, you are substantially burdening their exercise of religion. RFRA, importantly, has one big exception. A law is allowed to substantially burden the exercise of religion if, 1, there is a compelling government interest in the law, and 2, this law is the least restrictive means of achieving that government interest. This probably sounds confusing. It will hopefully make a little bit more sense moving on when we go into Hobby Lobby specifically. The important thing to know is that this standard is really, really high. It's nearly impossible to meet. So basically, RFRA says no laws can substantially burden the exercise of religion, and we have one exception, but the exception rarely ever works. So now into the facts of Hobby Lobby. This case actually involved 3 corporations. We're only going to talk about Hobby Lobby just for simplicity to just talk about 1 instead of 3. So Hobby Lobby is a craft store. At the time of the case, it had about 500 locations, and it is owned and operated by the Green family. So if you think about corporations like Disney and Amazon and Google, they can have up to millions of shareholders, which means like millions of people own Disney. Whereas Hobby Lobby has one family as the shareholders. They're operated by only one family. This is what we call closely held corporations. So that's the distinction between huge corporations and something like Hobby Lobby. So the family that owns Hobby Lobby, again, the Green family, they identify as Christian, and they believe that their religion does not allow certain birth controls. So they brought a lawsuit saying that the Affordable Care Act cannot force Hobby Lobby to provide women employees with certain contraceptives because it violates their religious freedom. Note, they're not saying that their employees cannot use birth control. They're just saying that they don't want Hobby Lobby to have to provide cost-free access to the birth control. They believe that that is in violation of their religious beliefs. So, what are the precise questions that you as attorneys and the judges have to consider in this case? The first question, does RFRA even apply? The Religious Freedom Act stops laws from burdening a person who is exercising their religion. So the first question is, are corporations people? Can a corporation be a person? If a corporation is not a person, RFRA doesn't apply and the contraceptive mandate is A-OK and Hobby Lobby has to provide birth control. So if you are the government, you say, nope, corporations can never be persons. They are entities, they're separate, they're not human, so how can they be a person and how can they exercise religion? But if you represent Hobby Lobby, you say, yes, corporations are persons for the purposes of this law. Closely held corporations are operated by a family. So Hobby Lobby is basically the Green family that's running it, and they're exercising religion. This is actually a harder question than it sounds. It's one of the most important questions that this case answered. So I think you'll have fun thinking about it and trying to figure out, is a corporation a person? The second question is, if RFRA, the Religious Act, applies, so if we say corporations are people sometimes, does RFRA's exception save the contraceptive mandate? So remember, if the government can show, like, yeah, this law might substantially burden you, but we have a really good reason, we have a compelling interest in this law anyway, and it's the least restrictive means of achieving that interest, then the law can stand, it's fine. So as far as compelling government interest, everyone probably agrees that providing women with access to birth control is a compelling government interest. Access to birth control allows women to better plan their pregnancies, which makes them more likely to complete their schooling, more likely to excel in their careers at the same rate as their male counterparts who don't deal with pregnancy in the same way. Birth control also has other health benefits like curing menstrual pain, etc. So ultimately, the government would say this is a health issue and it's a compelling government interest. Hobby Lobby can maybe say, yeah, it's an important interest, but it's not compelling. It's an employment question at the end of the day, not health. That argument's kind of hard. So if you represent Hobby Lobby, really try to think about whether this is compelling or not. The good news for Hobby Lobby, if you are their lawyers, is that the second step is very hard to meet. The government has to show that this law, the contraceptive mandate, is the least restrictive way of providing women employees with cost-free access to birth control. So if you are Hobby Lobby, if you can think of any other way that we can get birth control to women employees cost-free, besides having their employers pay for it, if there's anyone else who can pay for it, basically, you win this case. But if you're the government, you want to prove this is the least restrictive way. It's the most convenient, most direct way. There's no other equally effective way. This question is pretty hard, right? So you're going to have to, both sides, do your best to think about whether this really is the best and least restrictive way or not. So those are the important questions that you have to answer. And if this case sounds intimidating or confusing to you, that is totally okay. It's confusing to most lawyers, to judges. So the fact that you're working through it while you're in high school is fantastic. You are on your way to being great legal thinkers, and I hope you enjoy learning this case. Have a wonderful day.